We'll call to order today the Alabama Medical Cannabis Commission meeting agenda for October the 12th. I'm glad to have all of you here today, and before we go any further, I'll ask Dr. Sam Blakemore to lead us in a word of invocation.
Father God, thank you for another day. Thank you for everything you do for us each and every moment. Help us always trust in you. Help us always be guided by your principles. Help us always honor you. Help us do what we need to do today. In the name of Jesus we pray. Amen.
Amen.
Thank you, Dr. Blakemore. I now call on our director, John McMillan, to have a roll call. As you can see, we have several commission members on virtual today. So, John, if you will.
Chairman Vaughn.
Here.
Dr. Salisky is not available. Vice Chairman Blakemore.
Present.
Mr. Gamble.
Here.
Dr. Martin.
Here.
Dr. Jensen.
Here.
Ms. Skelton.
No.
Judge Price. Ms. Hatchett.
Here.
Mr. Harwell.
Here.
Dr. Saflarsky.
Present.
Mr. Robinson.
Present.
We have a quorum, Mr. Chairman.
Thank you, Mr. McMillan. We'll move further. We've got a few items to attend to today, but before we move any further, all of our commission members, those of you on virtual and those present here today, if you had a chance to look over the minutes from the last meeting, which was August the 31st, are there any questions or amendments to the minutes? If so, I'll entertain.
Last meeting.
Thank you, Ms. Hatchett. Have a motion from Ms. Hatchett to approve the minutes. Is there a second?
Second.
Got a second from Mr. Harwell. Any other discussion on the minutes from August 31st? All in favor, say aye.
Aye.
Any opposed?
Aye.
Aye.
Thank all of you. Before we move any further, we've got a few of attorneys of our legal attorneys with us today, so I'm going to recognize a few of them, and Mr. Mark Wilkerson will have a few comments to address what we're about to do. But here lately, Dr. Blakemore and myself have spent a lot of hours with our new attorneys that have helped us in many ways, and I'll ask each one of them to stand. Y'all all know Will Webster, and we have a young attorney, Mr. Walker, who just passed the bar, so he's kind of a new addition to our team. And y'all know Justin and Daniel, old timers, but also we have Mr. Mike Jackson. Mike, raise your hand. Scott Spiegel, and Mr. Mark Wilkerson, who you'll hear from just in a minute. They have been a great asset to us, and I never knew I'd spend so much time with attorneys in a room at one time, but they've been a great asset to our commission, helping us wade through where we are. And so they've had to digest a lot of information, where we've been, where we are, and where we're going. And so keep in mind that everything they've had to understand about the Alabama Medical Cannabis Commission and the rules and regulations, they've had to digest this extremely quickly, and they've done a magnificent job. And I think you'll see that demonstrated here in a minute from Mr. Mark Wilkerson. So, Mr. Mark, if you'll come forward to the podium and go ahead and address what we're about to do with our motions today, please, sir.
Mr. Chairman, thank you. And I do want to make sure that it's understood that I'm standing here today, but it is the collective work and wisdom of the council team, both existing and some of the new additions that you mentioned before, that I represent. As background, I want to start by saying that this commission has the right and really the obligation to get counsel about existing litigation and confidential communications. I want to make sure that nothing we do today waives that or suggests that you are not going to have those types of communications in matters in which litigation is pending and you are named in your official capacity as defendants. But I do need to talk broadly about the existing litigation in order to set the stage for the matters that you're about to consider today. As you're aware, the licensing process has been the subject of litigation related to the application submission process at the front end, the scoring of applications, procedures for the approval and stay of awards, the rescission of the initial license awards in June of 2003, for which we just got an order from the Circuit Court yesterday affirming the right of this body to take that action. The most recent license awards are subject of a temporary restraining order issued by the Montgomery County Circuit Court and have been administratively stayed by this commission pending further review. There is a hearing set in Montgomery County Circuit Court for next Wednesday on a request for preliminary injunction. We'll know more about the court's thinking after that hearing. But at the request of the Montgomery County Circuit Court, the Commission's representatives, your counsel, have participated in discussions with counsel for the litigants in an effort to permit the licensing process to continue. These negotiations have not resulted in a proposed agreement. The parties have different positions. They are in different positions. We did not expect a unanimous consensus would be reached, but they have helped to clarify the parties' positions and identify the issues that need to be addressed for this process to continue. The Commission staff and counsel have considered all of the available options to resume the licensing process in a defensible and expeditious manner. One option is to provide the applicants with an opportunity to present to the Commission, as part of further deliberations, many of the arguments that they are currently raising in court, including claims that the third-party scoring was flawed, or that exhibits that they sought to file with their original application were distorted or otherwise limited by file size limitations in the application portal. By providing an opportunity for applicants to make a presentation prior to further deliberation and voting, the Commission would also mitigate concerns raised by certain parties regarding alleged violations of the Open Meetings Act, which the Commission continues to defend in court, contest in court. So while the Commission arguably has existing authority to permit those presentations under its existing rules, we are asking the Commission to lean toward full disclosure and transparency, and to consider the promulgation of a rule setting out such process to provide maximum transparency and a clear roadmap for applicants so they know exactly what's going to happen next in this process. And given the time limitations facing the Commission and the need to expedite the availability of medical cannabis, we are asking the Commission to consider adopting such rule on an emergency basis. And the proposed rule 538-X-3-.20 ER, titled Special Procedures Relating to Certain Applications, has been provided to you. We've also provided that rule as a proposed rule to publish under regular rulemaking procedures. The Administrative Procedure Act permits adoption of an emergency rule and the beginning of rulemaking processes for a similar rule to be adopted on a permanent basis. The election before this board is whether you wish to adopt the rule that I mentioned on an emergency basis initially, to provide an opportunity for this board to process applications, to, if it so chooses and the court so permits, to vote on new awards before, hopefully, the end of the year. We worked with staff under the various timelines that are set out in the proposed emergency rule. The staff believes that would, if that would allow that process to be effectuated for all applicants for which you decide the award procedures should proceed by the end of the year. The regular rulemaking process takes longer. It's somewhere between 60 and 90 days. We believe would most likely 60, 70, 80 days for that process to work out before processes could be initiated pursuant to those permanent rules as well. So that is the time delay. Before we go into the text of the emergency rule, and that is the new rule we're proposing in addition to some other revisions to existing rules. I want to talk a little bit more about the criteria for granting an emergency rule. The Administrative Procedure Act permits adoption of an emergency rule upon the finding of an immediate danger to public health and welfare, requiring adoption of a rule on an emergency basis upon a fewer than 35 days notice. The rule can become effective immediately upon filing of the appropriate publication and filing of the rule with Legislative Reference Service. The burden is on this commission to make a finding that those emergency circumstances exist. And again, the language is immediate danger to public health and welfare. You have before you a proposed resolution. If you were to make that finding, that would sets out some of the legislative findings when the act was passed regarding the need for medical cannabis to be made available to patients in Alabama. We outline in that resolution the circumstances that have brought the commission to where it is today, and delays up to this point that I know the commission did not desire and wants to see resolved as quickly as possible. And also cites what we have discovered to be numerous communications to this commission from patients and caregivers urging the commission to make medical cannabis available on an immediate basis as quickly as possible. By awarding licenses, allowing the licenses to ultimately be issued and processed. A copy of a sampling of those communications to the commission have been provided to you with your material for this meeting. Walking in today, I was reminded by the chairman that we have Amanda Taylor, for example, among others here, who have attended these meetings in the hopes that they would see an award, a process that would allow that medication to become available to them and their loved ones. I know all of you are aware of the publicity associated with this and the demands that have been made known to you through various means regarding the necessity of moving forward as fast as possible. That has to be balanced, obviously, with the rights of the providers, many of whom have invested considerable sums in this process and potential facilities or other matters associated with their application. They, too, have a desire for swift resolution, but they also obviously want a resolution that gives them the understanding that they've had a full and fair hearing in front of the commission. So with that, I'd like to move, Mr. Chairman, if it's acceptable, to the proposed emergency rule. Okay. I'm going to start kind of in order. You have it in front of you. And again, it's 538-X-3.20 ER signifies it's an emergency rule. We'll start at the first paragraph. And this rule states that the procedures will apply only to license applications that were subject to an administrative stay issued by the Commission on August 31 or the court's TRO that's pending. That was intended to capture all the applications that are now stuck in the process. And two, and become subject to an award of license by the Commission on or after the effective date of the rule. As it stands now, you have no licenses that are subject to award because you have prior awards, you have a TRO in place, and you have an administrative stay on those prior awards. So this rule only affects applications that become subject to your award after it's passed. And assuming the court permits you to do that, that will be up to you in subsequent action if you were to decide to eliminate the stay and rescind your prior awards, thereby making those applications subject to award again. This is the procedure that would follow. I know that sounds convoluted, but that is the multi-step process. We wanted to make it clear that this rule only applies if indeed applications become subject to award. We're obviously not going to do something the court tells us not to do, and we're going to follow the correct procedure in getting these applications for you to consider whether to bring these applications back up for award. So that's the first point. Now that we go into the rule, we begin to address the issues that have been raised by the litigants in court that can be addressed from a procedural standpoint. You're going to hear the word procedure a lot during this discussion, because one of the questions that will be raised about rules is, can we adopt new procedures by rules or otherwise that affect pending applications? Okay, that's a legal argument people made. And I will tell you that the courts have generally said that rules that are adopted that deal with procedure, remedies, remedial rules, generally can be applied to pending matters. What can't be applied to pending matters are rules that change substantive vested rights of parties. That's kind of a common sense understanding of what the legal standard here. So we want to make sure that the intent of these rules are to deal with process issues and what we're procedural issues here. And we believe they fall within the primary goal of the Commission's rules, and that is to make sure your decisions are based on the merits of the applications before you. That's the overriding goal in which this commission is charged with following. So how do we address these concerns? Number one, we have in court what's been described as the 10 meg issue. You're probably more aware of that than you want to be. And that is the allegation of some applicants that they were prevented from filing full and undistorted copies of their exhibits on December 30, the application deadline, because of unknown size limitations in the portal. Now, there are other applicants that say, well, we worked through that process, or we found out about it, and we were able to deal with it. But some say that, no, we were required to contort exhibits, compress exhibits, or cut exhibits off, or in some cases weren't even able to get our exhibit through the portal, and we weren't able to subsequently get an opportunity to provide that to the commission. That's the claim. We do not know the extent to which that is an issue, because we haven't seen the truncated documents, obviously. But one of the ideas that came out of the discussions was to provide an opportunity for those individuals to provide what they can certify was the exhibit they sought to file by the date, but were prevented from filing, both in terms of an affidavit where they swear to the truthfulness. They made a good faith effort to actually file that exhibit with their application, and understanding we're only dealing with applicants here, people that actually got their application in, number one. And number two, they're also going to certify to the truthfulness of additional evidence they provide attached to their certification, which would be copies of the metadata of the document that actually shows this document was in existence at the time on December 30 and hadn't been changed since then. So that's actual evidence that the document existed as they said they did, and then a officer of the applicant is based on his knowledge that we made a good faith effort to file it. If those criteria met, if they're able to make that filing within 10 days of a license becoming subject to award, that's your decision, then they would be permitted to file a full copy of that exhibit. That's number one. Number two, redactions. The commission allowed applicants to file redactions, a copy of their application for public comment. I think the intent, perhaps not expressed, but the intent of that was to have only redactions dealing with trade secrets or other competitively sensitive information that didn't go to the core of their qualifications. However, different parties redacted different amounts of their application. And so we've had litigants who have said for purposes of the 30-day public comment period or other reasons, they can't tell what people asked for because their public application is too redacted. And the commission staff agrees the redactions were inconsistent. What this would do would be specify that redactions in applications for terms of public publication are going to be limited to personally identifiable information and trade secrets or competitively sensitive information. It gives applicants 10 days to submit a new redacted copy that meets that standard, and the commission reserves the right to make further redactions if they don't do that. So that's the second kind. Again, we're dealing with the same application, it's just what's redacted for public comment. Third, you're going to provide an opportunity, once that's done, for supplemental comments within 30 days. That's 30 days, again, from the same start date. Okay. The next deals with pass-fail items. You've heard concerns expressed about how pass-fail items were identified, were publicized, and the impact that may have had on the commission's review. This would provide all applicants who have been preliminarily determined to have one or more pass-fail items to provide a filing showing cause within 10 days. That's a written submission as to why their application shouldn't be rejected because of that pass-fail item. That means an applicant who's had a pass-fail item can file something with the commission to articulate their argument as to why that should not disqualify them from approval. Okay. Next, I want to skip a little bit in the proposed rule to go to the next point I want to raise, and that deals with third-party scoring and tabulations. As you know, there are claims that alleging the scoring was deficient in various areas. We've had claims speculating that the scoring is inconsistent for different reasons. And we also have general claims that they weren't given enough information about the scoring in order to articulate what's wrong with it. But this is how this proposed rule would address that. Again, within the same 10-day period, that the commission would release general scoring criteria used by the third-party scorers, along with information any information in the commission's possession regarding each scorer's training and qualifications, excluding personally identifiable information. That's just general information about what the qualifications that the scorers had that's in the commission's possession. Number two, we're going to address and provide notice of any instance where the same score was not used in scoring in the same sections of applications within a license category. Now, I'll tell you that it's my understanding that didn't happen. But this will provide an opportunity for the commission to tell the world that it didn't happen. Number two, in addition to those public disclosures, this would also provide an opportunity for an individual applicant upon a written request to see any scoring notes that might be in the commission's possession and scoring sheets regarding their particular application, again with the personal identifying information redacted. And they got to make a written request for that. It would apply only to their application, and they're going to be obligated to pay the fees that the public records laws would allow the commission to impose for the time and expense of redacting and providing that information. Okay. Now that gets us to public presentations. Once that all has been done, and again, this is on an accelerated timeline of we're looking at 30 days, right after that period, the commission would provide an opportunity for applicants in each of the license categories to make a presentation to the commission. And how would they do that? They would do that, they would be physically present, perhaps in this room or another room made available by the commission. Commission members or members of the public could watch in person or they could watch virtually. We have suggested time limitations for each category. We know there are a lot of applications. We tried to address that by limiting integrated facility applications to 45 minutes and all other categories to 20 minutes. This is an opportunity, but not an obligation. So to the extent applicants would not have to make that presentation, and many may wish just to rely on their application as filed. We are also addressing the request by some parties to have inspections occur before the commission votes. We found it logistically difficult to come with any way that the commission could get into a bus and go to all potential facilities before a vote. That would take time, and that would be difficult. But we would be permitting in this rule applicants to provide documentary evidence or video showing facilities described in their application, either current or proposed, as if they were making, you would typically make a presentation to the court based on your application. They can also provide that in writing, in form of a brief. Anything they want to provide that they're going to use during the presentation, they've got to file 5 days before the presentation, however, to ensure appropriate distribution and logistical arrangements. We have a lot of detail as to how many copies they have to provide and who they provide it to, but that's it. Then once that is done, as soon as practicable, the commission would set meetings in each of the license categories in whatever order it wishes to consider, deliberate, and vote on the applications. We have included a form of the process used by the commission at its last meeting, wherein the commission, in order to find an order in which these matters would be brought up for a motion, potential motion or vote, had a balloting process, basically. I'm calling it balloting. It was a informal scoring process. We have retained that process, but we've made sure and made clear that that's all going to be an open process and an open meeting, and it's not going to be an anonymous process to address concerns expressed in the litigation. That would provide, and we've also made it clear that just like the scoring doesn't bind the commission at all, you have independent judgment as to how you want to weigh the criteria when you deliberate. But that this process to determine how the order in which applications come up also doesn't bind you. Somebody that were to score somebody in that process may, after deliberations, when the matter comes up, you're free to vote as your conscience tells you you need to vote based on the merits of the application. So that is that's a long-winded explanation of the emergency rule. You have a permanent rule, too, that's identical to the emergency rule with the exception of the time date and the expiration date. An emergency rule can only stay in force for 120 days. The emergency rule says it'll stay in force for the earlier of 120 days or adoption of a similar rule, a superseding rule. So that's the difference between the proposed emergency and the permanent rule. Mr. Chairman, I think now it probably makes sense to, if the board were to desire to adopt an emergency rule, you have the resolution in front of you, so the appropriate motion, if that would be the decision of the board, would be a motion to adopt the resolution and proposed emergency rule as distributed.
Thank you, Mr. Wilkerson. As you have heard Mr. Wilkerson describe, they have delved deep into where we are at this point and done a lot of work on what we've seen, what we've heard, and I think that the necessary steps ahead dictate where we are. So Kind of keeping all that in mind, that these proposed new procedural rules and revisions to our existing rules are this is what we're looking at. And these proposed rules have been circulated to all of our commission members via email. I hope each one of you have had a chance to look at them and study the background verbiage on each one of them. So, having heard the explanation from Mr. Wilkerson, and is any other questions any of you have? Ms. Taylor.
I have a question. Just for clarity, so I make sure I understand, on point number 3, where it was if they had a pass-fail item, that is not an opportunity for them to bring additional information. It's just an opportunity for them to contest whether that should have been a pass-fail item. Is that correct?
Yes, that's the intent of the drafter.
Okay.
Thank you, Ms. Hatchett. Any of our other commission members have a question or comment? Any of you commission members on virtual call, do you have a question?
Yes, I do. And I'm sorry, this was a very long and winded explanation, as you eloquently stated. Can you now please say what you said in 30 minutes, in 1 minute, in a simple way so people like me can understand it?
Good luck with that, Mr.
Yeah.
Wilkerson.
I bill by the hour, so.
I'm not trying to be difficult. There is a lot of public that is listening to this, and they may have the same questions that I do. I would like to understand it in simple language, what you just said.
The proposed rule would permit a expeditious yet transparent process for all applicants to address the commission, to address the issues that have been raised in regard to their applications, including any suggested deficiencies in scoring process or et cetera, including the technical issues that they may claim had prevented them from providing their full exhibits. And it's intended to balance the rights and desires of the applicants for that full hearing with the commission's desire to bring this matter to a conclusion, to have licenses issued in an expeditious fashion.
Thank you.
Thank you, Dr. Zaflarski. Any other questions from any other commission members?
This is Judge Price. Can you hear me?
Who's that speaking?
Judge Price.
Judge Price. Go ahead, Judge Price. Didn't know you were online.
Yeah, I'm on the line. Mark, all of this will only be effective providing we set aside the votes we've already taken, right?
I didn't understand the last part of it, what you said, Judge Price.
Well, okay, you have votes out there already. We'll have to set those aside in order to comply with these rules, right?
That's right, Judge. You would have to.
Okay.
There would have to be a subsequent action to lift the stay.
Right.
And then for those awards that you wish to rescind those awards. And that would make the awards subject to award.
Right. Okay. So, see, that'd be the first step then.
That would be the timing's up to the commission. You do have a meeting on October the 26th, I believe, that's already been set. Judge, we're in your old haunts in the circuit court next Wednesday in front of Judge Anderson, and he's got a hearing on a preliminary injunction. Then we'll know more after that hearing. But assuming there are no impediments to the commission taking such action, you would have an opportunity to do that on October the 26th.
Okay, thank you. Thank you.
That is the intent, Judge Price, that at the October 26th commission meeting, we will have the opportunity to move forward or not.
Okay.
So
That's fine.
Okay.
That's fine.
Any other questions from other commission members? Well, thank you, Mark, for that explanation.
Okay.
It's very detailed, and we appreciate that. And
Mr. Chairman, I just are you anticipating a vote on all the rules or just the emergency rule? No. Okay.
so right now, we will entertain a motion unless there are any other questions for Mr. Wilkerson.
I make a motion that we approve the resolution.
Have a motion from Mr. Harwell to, who was that second from?
That's from
Eric Jensen.
Okay, thank you, Dr. Jensen. Have a second from Dr. Jensen. Any other discussion on that approval of that new rule, the emergency rule. It would be potential new rule of 538-X-3-.20 ER.
And that motion and second included the resolution approving the rule. Is that
Yes, sir.
the intent?
Yes, sir.
Thank you.
I'm going to ask Mr. McMillan to do a roll call vote. We have so many on virtual call today to make sure we get the vote accurate. Mr. McMillan?
Okay, Mr. Vaughn,
Yes.
Dr. Zaleski is not here. Dr. Blakemore,
Yes.
Mr. Gamble,
Yes.
Dr. Martin,
Yes.
Dr. Jensen,
Yes.
Ms. Skelton, Judge Price,
Yes.
Ms. Hatchett,
Yes.
Mr. Harwell,
Yes.
Dr. Saflarski.
Yes.
That carries substantially. Yes, sir.
Motion carried.
Motion carries. Thank all of you for your attention. And as Mark mentioned a second ago, the next item, number 2, on potential new rules is very similar to what we've just discussed and what we've heard. Mark, go ahead and discuss briefly why we have to take up the permanent rule here on number 2.
Well, I think as I explained, the permanent rule would take effect after the comment period, probably assuming it's approved by the commission, 60 to 70 to 80 days after publication. And it's just, it would supersede any emergency rule that had been filed. So it is just to provide an opportunity on a permanent basis because we can't 100% sure know what the timeline will be. We have hopes and expectations, but we don't know what's going to happen in court or in other matters. So that's just simply it. It's identical with the exception of the last paragraph.
Any commission members have a question for Mr. Mark Wilkerson pertaining to the second item of special procedures? Yes, sir.
Yes. Could you please, for us and for the public, articulate what is the best and the worst case scenario for the timeline?
Dr. Saflarski's asking that question. Mark, do you want to address that?
Yes, and Justin or the chairman may want to address it as well. But for what we have seen, the best case scenario for the emergency rule timeline would be a new commission award for any licenses that are subject to award by December. And that'd be the best case scenario. The worst case scenario would be it would depend on obviously if a court intervened in any way. We don't know what, we have a hearing on Wednesday, and so that if there were any judicial delays associated with the process, that would delay a process obviously. If the commission were to not decide not to have hearings or delay presentations, delay the presentations, that would be up to the commission. But we believe, as set out, the best case scenario is early December. The worst case scenario, based on the emergency rules and without judicial intervention, would probably be January. But everything has targeted toward December based on the time limitations in the emergency rule.
Thank you.
Thank you, Dr. Saflarski. Any other questions from any other commission members? I may go back briefly. The emergency rule that was just adopted by the commission is effective immediately. And I don't know if Mark will address this a little bit, but we have an aggressive, rigorous timeline ahead of us, as Mark just mentioned. So it's important that we get these things in place to set the stage of what we're about to do, because the next 2 to 3 months will weigh heavily on the commission that we move expediently. So once again, I thank our legal team for getting us in this situation to provide a platform for the applicants to have their time. I'll now entertain a motion to adopt the permanent version of the new rule 538-X-3-.20. Is there a motion to adopt this permanent rule?
I'll make a motion to adopt the permanent rule.
Thank you, Dr. Blakemore. Got a motion from Dr. Blakemore. Is there a second? Got a second from Mrs. Hatchett. Is there any other discussion on that version of the new rule? I'll ask Mr. McMillan to give a roll call for a vote.
Mr. Vaughn?
Yes.
Dr. Salisky is not available. Dr. Blakemore?
Yes.
Mr. Gamble?
Yes.
Dr. Martin?
Yes.
Dr. Jensen?
Yes.
Ms. Skelton's not available. Judge Price?
Yes.
Ms. Hatchett?
Yes.
Mr. Harwell?
Yes.
Dr. Saflarski?
Yes.
Unanimous of those participating, Mr. Chairman.
Thank you, Mr. McMillan. We've got some proposed revisions. It won't take a lot of explanation on these, I don't believe, Mr. Wilkerson, but before we move any further, I'll ask Mark if he wants to explain. We've got 6 items that are actually potential revisions to our existing rules, and I believe we can take all of these in one motion, but I'll ask for just an explanation, Mark, before we move forward with that motion.
Yeah, I'll be happy to. And the most significant revisions you see are in 538-X-3-.18, and that deals with the investigative hearing process following a denial of application. And just very quickly in bullet points, it provides specificity as to who has to be served with a request for investigative hearing and how that occurs. It eliminates the license fee requirement in the existing rule. One of the criticisms that's been heard in court and elsewhere is that the requirement that a party that's been denied pay the licensing fee up front before he challenges that ruling is a barrier to exercising his right for an investigative hearing. This would eliminate that requirement. It provides specifics that are permitted under the Administrative Procedure Act for the agency to conduct that hearing. It allows the agency to appoint a third-party hearing officer, and an example of that would be perhaps a state attorney who serves in that capacity for another agency that was used to conduct the hearings. If the commission desires that, these are all may issues, not must issues. It provides the hearing officer, it provides for intervention rights and processes for intervention in that hearing. It provides the hearing officer with a right to use various procedures to streamline the hearing process, for example, requiring pre-filing of testimony in advance, etc. Allows them to consolidate denials within one license category for purposes of the hearing. But again, these are just options available in those hearings and are procedural in nature. The remainder of the proposed revisions are technical in nature. In 2 occasions, obsolete code sections are updated. Administrative code sections that are cross-referenced or they're updated. In other instances, we simply included provisions such as except as otherwise provided in these rules or ordered by the commission as a qualification to what's said in the rule. That's all, and they're pretty self-explanatory. You read through them, and with that, it'd be, if there are no questions, it'd be subject to a motion to adopt. I think you can do that for all of the proposed rules. Again, these are for publication and comment.
Thank you, Mr. Wilkerson. Before we move forward with a proposed motion, I'm going to identify all 6 of these items so that our members joining us by virtual can keep track of what we're talking about, but they will be taken up in one motion. So bear with me. These are potential revisions to existing rules that we are going to maybe entertain a motion for momentarily. The first one being 538-X-3-18, the denial of application, request for hearing from application denial. Item number 2, 538-X-3-13 is a public notice and comment period prior to a public hearing. Item number 3, 538-X-3-.12, third-party evaluation and recommendation. How do we accommodate that in the existing rules? The fourth item, 538-X-3-10, processing and evaluation of applications. Item number 5, 538-X-3-.04, applications and applications processing in general. And the last item on this motion will be the Appendix A, be a timeline for the applications and the licensing before us. So I'm now entertaining a motion that we move forward with the adopting these proposed revisions to the existing rules of the commission as provided to the commission members. Hopefully all of you have had a chance to review all of these over the weekend in advance of today's meeting and as explained by Mr. Wilkerson. Once again, Mark, thank you for your work in explaining, getting us to this point, you and your team. Appreciate that. But this motion will be in one vote. So keep that in mind. We're approving all 6, if you see fit to do so, in one motion. Is there a motion to adopt all revisions that were proposed to the existing rules?
I make a motion to adopt the revisions to the existing rules.
I have a motion from Dr. Blake Moore to adopt the new rules, existing potential revisions. Is there a second?
Second.
Got a second from Mr. Harwell. Is there any other discussion or questions from members present or on virtual? Hearing none, I'll ask Mr. McMillan to move forward with a roll call vote.
Mr. Vaughn,
Yes?
Dr. Blakemore,
Yes.
Mr. Gamble,
Yes.
Dr. Martin,
Yes.
Dr. Jensen,
Yes.
Judge Price,
Yes.
Ms. Hatchett,
Yes.
Mr. Harwell,
Yes.
Dr. Saflarski.
Yes.
Unanimous with those participating, Mr. Chair.
Thank you, John. Motion passes. Thank you for enduring our legal discussion today. As Mark mentioned a while ago, a lot has happened since our August 31st meeting, and a lot is about to happen going forward. A lot will be asked of our commission members in the days ahead, so be watching. I think Ms. Peters will be sending out a tentative dateline as to what meetings may be occurring. So we've got a lot in front of us, and it's an aggressive schedule that we're going to do our best to stay on as the court accommodates us. So we'll see how that plays out. We have a hearing next week, as he mentioned earlier. Couple of old business, new business items. The emergency rules as adopted today will be published on the commission's website this afternoon, so all of you can make note of that. The staff has looked at some hypothetical timelines for moving forward, as I just mentioned, and Ms. Peters will post that probably, maybe if not today, soon. The timeline will depend on future actions of the commission and what the court allows. It also goes back to our October the 26th commission meeting and what we're able to accomplish at that point in time. But we'll see a path forward, and our legal team has really set the platform and the stage for us to move forward swiftly. And when I see people like Amanda Taylor here today, it reminds me of how swift we need to move. Our goal is to get to have a victory lap by the end of the year. But we'll see how that goes. But it's going to take a lot of work on the part of our commission members. Those of you on virtual today, a lot of time is going to be required of you in the days ahead. So be looking at emails and make yourself available as much as possible. We need to give these applicants a lot of our time because they're due it. The applications they have put in front of us are worthy of a deep consideration, and we need to be looking at all of them with as much due diligence as possible. Any other discussion? Keep in mind, October the 26th, there will be a meeting probably right here in the State House. This will be our meeting place for the foreseeable future unless Ms. Peters lets us know otherwise. So, and more than likely, when we move ahead with the applicants' presentations, we see very likely that may take place here as well. So keep that in mind. Any other questions or comments by commission members here present? Those on virtual, anybody got any questions or comments? Do I have a motion to adjourn?
Make a motion, we adjourn.
Got a motion from Mrs. Hatchett.
Second.
A second from Dr. Blakemore. All in favor of adjournment, say aye.
Aye.
We stand adjourned at 1:50 p.m. Thank you.